Pass over case item 5, criminal revision 63 of 2022.
Hope the reply has come on record. I hope the reply has come on record.
This is for competition or delay?
Yes, Your Lordship, and on the last date, I was also directed to file to indicate if the maintenance is being paid up to date, Your Lordship. We have also filed a lot of receipts, and the opposite party number 2 was also arrested for not paying maintenance in August 2023, Your Lordship. After that, he has made payments, but I think 3-4 months arrears are still left, which he's saying he'll pay. And also, we've suggested him to go for 127 himself because he has been suspended from his services, Your Lordship.
The petitioner has come for
Enhancement of the maintenance amount, Your Lordship. Last date's order may be seen, Your Lordship has taken note that 127 he can go for section. Yes, Your Lordship, that has already come on record. But Your Lordship, his IFR limitation was pending, Your Lordship. That is for more than 1400 days, Your Lordship.
yes, you have a remedy under 127. What is the original date of fixing maintenance?
Original date of fixing maintenance is
29 June 2016, Your Lordship.
29/6/2016.
2016, Your Lordship.
What was the amount?
Your Lordship, 10,000 amount was to be paid, Your Lordship.
10,000 total.
Total.
To wife and children both?
Yes, yes, Your Lordship.
How many children?
One.
One child. Then she preferred what did she prefer?
She has preferred this criminal revision basically to enhance the amount, Your Lordship. She wants the amount to be enhanced to 15,000 per month. We also had come earlier before this High Court filing a criminal revision for quashing of that order, Your Lordship, which had been rejected. That is Annexure 1 of the petition. That was passed on 14th February 2020, Your Lordship. Now they have come before this Honorable Court in 2022, Your Lordship, against that order, Your Lordship.
Just a minute. 948 last. The OP was heard.
Yes, Your Lordship.
What is the finding of this court?
It was dismissed, Your Lordship.
Simplicity dismissed?
Yes, Your Lordship.
There is a finding also that the petitioner who is a teacher
Yes, Your Lordship.
and getting a salary of 38,400 has been directed to pay rupees 10,000 to his wife. The amount is not excessive. Now, the same order is being challenged by the petitioner.
Yes, Your Lordship.
What was their claim? What was their claim?
Now they are claiming for 15,000 every month. They are saying that the son is mentally undergoing some treatment, Your Lordship, for his mental ailment, Your Lordship. That's why they want increase in the maintenance.
They
amount.
had prayed for 15,000 and granted.
Now in this revision, Your Lordship.
In this division, no,
Yes.
they had applied for 15,000. See the improved order first page. They had applied for
Yes,
15,000,
Your Lordship.
but was granted 10,000.
10,000.
So they say that this quantification is not right. Okay?
and you have written Milord.
Your Lordship,
She has said Milord ki.
for the iron limitation may be seen, Your Lordship.
How much is it?
1400, more than 1400 days delays there, Your Lordship.
What is the ground for delay?
Milord Brown ki now his payment is 75,000 and lots, Milord. A very less amount is being paid, Milord.
So you want to say
And-
that now the payment or pay of the opposite party number 2 is 75,000.
75,000.
So you want that it should have been fixed at 15,000.
That was earlier, Milord. It should be paid, Milord,
Proportionately
more,
increased.
Milord, more, Milord.
Okay, you are claiming more.
My,
So under 127 you can go and file your petition.
my lord, you may direct, Milord.
Is that okay, madam?
And then
127 they have a
Yes, Your Lordship,
remedy.
they anyway don't have a remedy account.
Right, so delay can
She
be
has
settled.
Your Lordship, 1400 is, and
So what's
their,
the big deal about
Your
it?
Lordship,
I
their
will reject it
reason,
on merits.
we filed the reply on that, Your Lordship. Their reason for asking for condemnation is that they could not obtain the copy of the criminal revision order, Your Lordship, that we had applied for. That was not at all required, Your Lordship, for filing this revision.
Where is that item?
I number 905 of 2022, Your Lordship.
What is the date of the impugned order?
29 June 2016, Your Lordship. 1264. The reason has been stated in para 5, Your Lordship.
So they are seeking 23,200. Just
No.
enter this,
Yes.
right?
Yes.
in this case, Milord, can one thing, Milord. He has petitioner has said, Milord, कि I have been suspended from my service. Actually, इतना तो मैं
We are not concerned with that.
हाँ,
We are not concerned with that. If you want any modification, maybe that he also wants some modification.
my
So that you have to take care of under 126
120,
and not under 120.
my
Okay, the learned counsel for the parties are present. This is IA number 905 of 2022 with criminal revision number 63 of 2020. This revision has been filed for the following relief. The counsel for the petitioner has submitted that there is a delay of
1246 days.
1240
64, Your Lordship.
1264 days in filing the present revision application. And the same could not be filed as the revision application filed by the opposite party number 2 being criminal revision number 948 of 2016 challenging the order of maintenance was dismissed on 14/2/2020 and thereafter there was pandemic situation. The learned counsel for the petitioner on the merit of the case has submitted that although the claim for maintenance before the learned family court was only to the extent of ₹15,000, but the same was fixed as well as on 29/6/2016, and thereafter the salary of the opposite party has increased to 75,000,
75%.
sorry,
Per month.
75,000 per month, and therefore the petitioner is seeking an appropriate order from this court for maintenance of rupees 23,200 per month instead of 10,000. The learned counsel appearing on behalf of the opposite party by opposing the prayer for condonation of delay has submitted that the issued order was passed on 29/6/2016 and the same has nothing to do, and the present proceeding has nothing to do with the criminal revision filed by the opposite party number 2, inasmuch as the opposite party number 2 was challenging the order of maintenance, and the present revision application has been filed for enhancement of the maintenance amount. She submits that the petitioner, if so aggrieved by the order dated 29/6/2019, passed in the maintenance case 2016, passed in the maintenance case, had to file her independent revision application against the same order at the appropriate time, so that the two revision petitions filed by the petitioner as well as the opposite party number 2 would have been tagged. The council submits that the order, the no ground for condonation of delay has been made out. So far as the merits of the case is concerned, the learned counsel submits that in order to seek enhancement of quantum of maintenance, the petitioner has a remedy under section 127. However, in the affidavit filed by the opposite party number 2, it has been stated that the opposite party number 2 is under suspension.
Yes, so much. Now we've annexed also the suspension
His
order.
suspension was revoked, my lord.
In response, the counsel for the petitioner has submitted that the suspension order
Has been
of the opposite party number 2 has already been revoked.
Revoked. Why
And
then
therefore, the
accept?
present petition should be allowed and the delay be continued. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that the petitioners had filed a petition seeking maintenance under section 125 CRPC for an amount of rupees 15,000, out of which maintenance of rupees 10,000 was allowed by order dated 29 June 2016 in miscellaneous case number 24 of 2012 by the passed by the principal district judge East Singhbum Chaibasa, West Singhbum Chaibasa. The petitioner did not file any petition challenging the said order for challenging the said order. Rather, the opposite party number 2 had challenged the said order in criminal revision number 948 of 2016, which was dismissed on 14/2/2020. This court is of the considered view that the petitioners, having not challenged the order dated 29 June 2016 within the stipulated time, had nothing to do with the criminal revision number 948 of 2016, which was filed by the opposite party number 2, and therefore the pendency of criminal revision number 948 of 2016 or the COVID situation after 14/2/2020, when criminal revision number 948 of 2016 was dismissed, cannot be a ground for condonation of delay. Accordingly, this court is not inclined to condone the delay, enormous delay in filing the present revision application. This court has also gone to the this court also finds that the petitioners are seeking enhancement of maintenance to add rupees 23,200 200 instead of 10,000 as given by the learned family court. Although at the appropriate time a claim of rupees 15,000 was made. The reason for seeking enhancement is that the salary of the opposite party number 2 has increased. This court finds that in case of any subsequent development after the order passed under section 124 of 125 of CRPC, the parties had appropriate remedy for modification / reduction / enhancement of maintenance in terms of section 127 CRPC, and the present revision petition is not maintainable for the said relief. Accordingly, this revision petition is also dismissed.
Item 10, criminal revision 957 of 2022.
ट्रायल कोर्ट का ऑर्डर नहीं आता है, रिविजन है लगा हुआ इसमें है। एक साथ लगा हुआ था, इतना ध्यान नहीं। Yes, petitioner.
I was under impression that it is listed under the
इनको ये आप क्या कौन है आप complainant?
Actually, I have received this file through NOC, so I have to do.
You see, the criminal appeal was filed against judgment of conviction, and the criminal appeal has been allowed. You have challenged the order of acquittal, judgment of acquittal passed by the learned appellate court.
Only not today.
This may not be maintainable. Against an order of acquittal, you have to examine this also. How much time do you need?
1 week.
The learned counsel for the petitioner seeks adjournment. Pose this case under appropriate heading on 29th of February.
No, 29th.
You said only 1 week.
Actually, 29th, there is some difficulty with him.
28th.
Okay.
28th is a Wednesday. On 7th of March, you find out whether this revision would be maintainable under appropriate heading.
Passover case, item 34, criminal revision 624 of 2022.
Who's for the petition?
Apologies, Your Ladyship. I spoke to the client, Your Ladyship. They are saying that paternal property could dispose of करके they will do this. But Your Ladyship, there are two contentions that I want to raise before this court. Number one, Your Ladyship, I had made a submission that December में उनका operation हुआ है. That is not the fact, Your Ladyship. It is a senior engaged matter, and the counsel had informed me that December में हुआ है. When I spoke to the client myself, I have been informed that January 2021 में हुआ था उनका kidney transplant. They are still under recovery, but that is the scenario, Your Ladyship. And secondly, I spoke to the client. They have informed me that they have given a second proposal, that is a week back on 13th of February to the bank. and they have spoken to one Mr. Gupta ji, who is the circle head of Punjab National Bank, for approval of it. There they have proposed that they will pay 1 crore 51 lakh rupees towards the one-time final settlement, which will be paid within 20 months. Now,
And therefore, and all the auction sales will be set aside.
Regarding auction sales, they said that they are waiting for confirmation of the same.
Yes, council, where is Mr. Patti? Where is he?
He's in court number 2.
Arguing the matter. Call him, please. Let him call him. Call him.
Your Worship, I just want to make one submission that my client has said that he has asked Mr. Gupta ji to give in writing that they are in consideration of this particular
No,
settlement.
that will not solve the problem. We will send you to Jhalsa and this manager should also be there. And you settle whatever your dues are, whatever it is.
Yes, ma'am.
Mr. Patti, it seems that some properties have been auction sold, and it further seems that they are wanting some kind of compromise. Then whatever has been sold, whatever be the dues, whether this amount is over and above that due, we do not know. So can we send it for mediation?
Well, Lord, I have taken instruction as on mediation.
That would be the best.
But the difficulty is that as on date,
Third party, now it's auction sale cannot be set aside, that will be a problem.
no, there are further properties to be auction sold. The valuation of the property was the previous valuation. Current valuation has not been obtained, was around 4 crores. The dues as on date is more than 6 crores, 6.5 crores. And what they are offering is 1.5 crore. So
So this
that
amount,
is the problem.
this check amount can also be subject, if that dues is inclusive of this or excluding this check amount.
Well, this includes the amount of loans, not over and above that.
It was a security check that we had given.
No, it was not a security check, it was for repayment.
My instruction.
8 crore check will be well security. That was the, it's better, right? Let us send it to mediation.
It can work out.
It can work out. When will you appear before the mediator? You ask your regional manager to be there because otherwise the branch manager will not be.
My lord, I have taken instruction, spoken to the officer. There is a separate branch, it is called Sastra for stressed assets, and it's headed by the AGM. He will go himself with the copies.
Stressed asset branch.
So it's Sastra, SASTRA, Sastra. ASTRA, Sastra head. He is called the branch, Sastra branch head.
He is the regional manager.
No, he is a AGM, senior officer.
AGM.
Yes, AGM is heading it.
Which is that bank?
Punjab National Bank.
Yeah. The learned counsel for the parties are present. The learned counsel for the parties submit that the matter arises out of bank loan and some of the properties have been attached by debt recovery tribunal and certain proceedings regarding auction sale has already taken place. The councils have jointly submitted that the matter can be resolved through mediation as the petitioner has also been approaching the bank for mediation, for settlement.
Settlement. But the offer is on the
But the offer given by the petitioner is not up to the mark as the valuation of the property which is yet to be sold is much higher than the amount which is offered by the petitioner and consequently the bank is in difficulty in accepting such an offer as per the applicable norms for entering into finance. However, it has also been submitted that the matter can be can be settled through mediation and it may be referred to mediation at Jharkhand. The learned counsel for the responding bank has also submitted that he has taken instruction that the authority who would participate in the mediation is a high-ranking officer that is the Assistant General Manager of Punjab National Bank in branch dealing with stressed asset known as SASTRA, head ETA. Let this matter be referred for mediation. Considering the submissions, let this matter be referred to for mediation in Jharkhand state in Jhalsa. The parties to appear before Jhalsa on
Any Saturday will be
day after tomorrow.
next week Saturday.
On 31st.
This February 29th.
2nd March.
You see, Saturday will not be convenient for the bank. Right?
Won't be.
So we have to take care of that. On 29th of February,
Very well, Your Ladyship.
2024 at 11 a.m. Upon their appearance, the Learned Secretary Jhalsa shall appoint a mediator for the purpose, and let the mediation report be submitted before this court by 7th of March. 31st March is approaching. This is the right time to hit.
Yes, Your
Okay.
Ladyship.
That is why I have given date 7th of March. Once 31st is over, the matter ends.
Payment comes before 31st, they will be agreeable for
And
something
you
less
tell your
also.
client that she has to arrange the payment prior to 31st.
I will. Much obliged.
Obliged.
Item 4 fixed as a at 215 as a first base. Criminal Revision 56 of 2022.
Yes, petitioner. You are there for the state.
Yes. Mr. PDR.
Who is seeking passport?
किसका तरफ से पास हो गया? ध्यान में किसका तरफ से लिए?
Various MS Rakhi Rani. Now in the platform. Where is she? On the last date, she said that she has not read the brief. So we had adjourned her. Today she is absent. She must be there in some school. कोई आइए नहीं है
Yes.
Opposite party is absent. State?
It is coming, Mr. PDR. I am called.
So
I
what
have
should
already
we do?
informed. He is left in the port number 10. He is coming.
You call him please. Right?
Yes.
ये पास ओवर करते हैं।
बिल्कुल तो है ही नहीं, आप किसका तरफ से?
अगर मैडम राखी रानी नहीं आएंगी तो किसी को अमेरिका से अपॉइंट करते हैं।
ये उन्हीं का तरफ से प्रेयर करना। ये उन्हीं का तरफ से प्रेयर करना।
कोई बात नहीं, किसी कोर्ट में होंगे। आप इन्हीं की तरफ से प्रेयर कर रहे हैं। तो इधर से प्रेयर। दिस साइड, दिस साइड। पिटिशनर की साइड से प्रेयर। Yes.
Item 37 Criminal Revision 670 of 2022.
Yes, petitioner.
My lord, in this case, according to routine order, the petitioner has been directed to pay the maintenance 5,000 per month to wife and 3,000 to minor son. In this case, my lord, petitioner is out of service February 2019, my lord, and that
When
fact
was
has
the
not
order of maintenance passed?
My lord,
Past
7/5/2022.
No. When the 7/5/20.
seven.
Okay, just
और उसके पहले से ये नौकरी से बाहर है, उसका केस भी हाई कोर्ट में चल रहा है, इसलिए हमारा इसमें पिटिशनर का प्रेयर है कि मेंटेनेंस कुछ कम किया जाए, फिर भी इंसिडेंट हो गए तो फिर हम देते रहेंगे, कुछ कम किया जाए।
आप कब से आउट ऑफ सर्विस है? February 2019 से।
हाँ 2019 से।
आपने लोअर कोर्ट में ये प्ली लिया होगा ना?
हाँ
You are
ये
out
है,
of-
इसमें भी आया है, इसमें आया है ये पेज नंबर 47 para 8 OP खाली as OPW admitted that the marriage and birth of petitioner two out of wedlock. Further, he deposed that presently he is unemployed. He was posted as a manager in Punjab National Bank. He has been dismissed from service since petitioner number used to visit office. उस पर हम नहीं जा रहे हैं मैम, ये जो है सो नीचे में आया है कि till February 2019 he used to send money account, ये तो मेंटेनेंस जो दे रहे थे सो सब है, ये उसका इलेक्शन भी हम लगाए हुए हैं, ये उसके पहले पेज नंबर एनेक्सर 3 के द्वारा।
That's right. Let us take that he is out of employment. So,
आउट ऑफ एम्प्लॉयमेंट मतलब ही आउट ऑफ सर्विस मतलब कोई इनका कहना है कि कुछ कम किया जाए, हम देते रहेंगे, इसमें कोई दिक्कत नहीं, लेकिन अभी हम सर्विस में नहीं हैं और उसके अलावे 3 लाख रुपये हम बेल के समय भी दिए थे, वो चीज़ एडजस्ट करने के लिए तो वो चीज़ इसमें दिया गया है।
वो तो adjust किया गया है।
हाँ
That has been adjusted.
Already.
हाँ एडजस्टेड, तो
8,000 rupees. Total 8,000, no?
My lord, 5
And
to me and 3
5
to my
plus
child.
3.
5 + 3 तो
5 plus 3.
तो अभी
Minimum wages से भी कम हो गया है।
मिनिमम
Minimum
वेजेस
wages कितना है?
तो मालूम नहीं।
Yes. You should know that.
अब बात है कि ये
Otherwise you are fit and fine.
अभी जो है सो तो इसका तो हार्डशिप फेस
क्या
करने केस
hardship?
में
No hardship.
केस मुकदमा अभी इनका चल रहा है, अभी
केस
स्टेट नहीं
मुकदमा के लिए आपको कुछ और काम करना पड़ेगा during the time you are
और
unemployed.
उसके अलावे ये भी हुआ है कि एनेक्सर 4 मैडम लेडी इज वर्किंग एक्सपीरियंस, ये कंप्यूटर वगैरह जानती है और पहले काम भी करती थी वोडाफोन में मैडम, और हिंदी इंग्लिश उर्दू सब जानती है, और तो इसलिए वो भी अपना काम करती है, तो उसको भी अपना कुछ कमा लेती है मैडम। अब अभी प्रेजेंटली कहाँ काम कर रही सो तो मालूम नहीं, लेकिन पुराना वाला ये सब है कि पहले 10,000 रुपये वो कमाती थी,
My lord,
प्रेजेंटली कमा रही कि नहीं कमा रही ये नहीं कर सकते, लेकिन पहले कमाती थी एनेक्सर 4 मैडम, तो कमाने के लिए वो भी सक्षम है, तो वो भी कमा रही कुछ, और ये आउट ऑफ सर्विस है, तो इसी में है कि अमाउंट उसको कम करने के लिए। फिर अगर मान ली सर्विस उनका रीइंस्टेट हो जाएगा, काहे कि 5 साल के करीब हो चला, 4-5 साल आउट ऑफ सर्विस।
आपको लग रहा है डिफॉल्केशन ऑफ मनी में आपको रीइंस्टेटमेंट होने वाला है इतना आसानी से?
अब जो भी अभी तो
इसीलिए बैंक में
अभी तो अब चलते रहेगा ना,
वेरी सीरियस थिंग।
अब तो हार्डशिप तो फेस करना ही ना है, जो भी अब हो या नहीं हो केस तो लड़ते रहना है, बस इतना ही प्रेयर और कुछ नहीं। फैक्चुअल एस्पेक्ट यही है, इसी पर हमको करना है, लीगल एस्पेक्ट में कुछ नहीं करना है, बस फैक्चुअल की लेडी से पढ़ी लिखी है, वो कंप्यूटर वगैरह जानती है, वो काम कर रही थी पहले वोडाफोन में, अभी काम करती है कि नहीं करती है वो तो हम वो नहीं बता सकते। लेकिन वो रेगुलरली पहले काम करती थी। कब सर्विस इनका स्टेट होगा। 12-11 में वो सब बात है। पॉइंट नंबर 3 रहेगा OP has sufficient means and what is his clinical condition. Page 49.
My lords, if I may be permitted, I wanted to point out things.
इसमें ये खारिज करके कह दिया गया कि क्योंकि he was not declared insolvent by any court.
Please, what do you want to say?
My lords, in the impugned order, if my lords come to para number 8, my lords, in the lower portion, my lords, para number 8, it's page number 47, my lords. If I may be permitted to read, my lords. 8, subpara B, my lords. Remaining all 4 opposite witnesses deposed in the same tune as opposite party that he has been dismissed from service. Now he earns by private tuition. They further added that petitioner number 1, which is me, my lords, works in Vodafone company. It is neither in the evidence of OP nor is in the pleading. My lords, if I may be allowed to read the next page, that is 49, my lords. From 48 lower portion, my lords, again in para 9 subpara B, my lords, the opposite parties 2 to 5 deposed that petitioner number 1, wife, works in Vodafone company. My lords, this is to be considered, but the OP himself as OPW1 did not depose, so nor does he plead in its show cause. But additionally, it has been well settled by the Honorable Supreme Court in this matter whether the wife is working or not. That is inconsiderable in matters pertaining to deciding maintenance. The main fact is to be taken into consideration whether the husband is capable to maintain the wife, my lords. My lords, I am relying on Rajneesh versus Neha and some, if my lords be permitted. My lords.
Rajneesh versus Neha
My lords,
says that
para
in
9
all
to-
the cases, affidavit of disclosure is required to be filed.
Indeed, my lords.
Has it been filed here?
Well, not affidavit of disclosure, not in record, my lords, but what I am trying to put.
But that
My
is the
lords, I-
mandate of the
my
Supreme
lords,
Court.
if that is
It
record,
may
I'll.
not be binding on you,
My
it
lords,
is
I'll-
binding on me.
Indeed, my board of my lords, I'll submit a supplementary affidavit filing a disclosure of that.
That will be done before the learned.
My lords, in that
But in the
case,
meantime, I will fix this interim maintenance
my lords,
and that will be subject to the result. Both of you file your disclosures.
my lords, much obliged.
Right? I was looking for that only. Because both of you are telling that they have source of income.
My lords,
Right? He says that you have source of income and you say that he has source of income. Right? But there is nothing, and lower court only says that you have not, in show cause it is not mentioned, but
Mentioned neither in the
affidavit of
pleading.
disclosure is not.
my lords, I would humbly submit one point. My lords, the Honorable Supreme Court in this regard has already said that even if the lady, as in the wife, is working, that would not bar the person from
Certainly, there is no
my
doubt
lords.
on that.
Yes,
There is
my
no
lords.
doubt. Very recently, we have passed an
Certainly.
order of a doctor, both of them doctors.
My lords.
But this compliance was not done.
My lord, one more factor needs to consider there's a minor child, my lord, of 2.5 years.
We will
Rajneesh Mrs. Neha,
we
that
will
has
not
also
interfere with the
Much obliged.
maintenance amount, but that disclosure has to be there.
Much obliged.
बोलिए।
ठीक है, इसको नीचे ही भेज दिया जाए वहाँ पर, दोनों अपना
लेकिन ये मेंटेनेंस अमाउंट देखते रहना पड़ेगा। ठीक है?
कुछ थोड़ा कम कर दीजिए इसलिए
तो
क्या
वैसे
होता है
कोई- हम तो अपना हमारा बस चले तो आपको पूरा आसमान दे दें, लेकिन नहीं दे सकते, ठीक है? इसलिए इतना 8,000 रुपीज आपको देना पड़ेगा, क्योंकि there is a sufficient description, right? And it will be subject to that, right? The learned counsel for the parties are present. This petition has been filed against order dated 7/5/2022, judgment dated 7/5/2022, passed in original maintenance case number 23 of 2019, passed by learned Principal Judge Family Court Hazaribagh, whereby, and to the minor daughter at the rate of ₹3,000 per month till her majority, till her marriage or majority as maintenance, and arrears were directed to be paid by first of every calendar month commencing from the next month. The learned counsel for the petitioner has submitted that the interim order passed by the learned family court calls for interference inasmuch as the learned family court has not properly considered the fact that the petitioner has been dismissed from the services of the bank, and therefore the petitioner has no source of income. The learned counsel has also submitted that the opposite party number 2 has enough source of income to sustain herself, and therefore also the interim order calls for interference. The learned counsel appearing on behalf of opposite party number 2 while opposing the player has submitted that the factum of dismissal of the petitioner from service has been taken into consideration. He has also submitted that the petitioner did not produce any document to show that opposite party number 2 had independent source of income. He has further submitted that so far as the petitioner is concerned, he was having his further income through tuitions, as has been mentioned in the interim order. The learned counsel has submitted that the petitioner is under an obligation to maintain his wife, and it is not material as to whether the petitioner is employed or not employed. The fact that petitioner is an able-bodied person, he has an obligation to maintain. This aspect of the matter has been considered by the learned family court, which suffers from no perversity and therefore no interference is voluble. The learned counsel has also submitted that in the judgment passed by Honorable Supreme Court in the case of Neha versus Rajneesh, reported in bracket 2021 bracket close 2 SCC 324, it has been clearly held that merely because wife has some means of livelihood, the same by itself is not a ground to deny maintenance to the wife. He submits that it has been taken into consideration that the obligation of the husband to maintain his wife is on a higher pedestal. However, during the course of argument and upon going through the judgment passed by the Honorable Supreme Court in the case of Neha versus Rajneesh versus Neha, and upon a query put by this court to the learned counsel for the parties, it has been fairly submitted that the direction for filing disclosures by the respective parties in terms of their postage judgment has not been complied by the learned court, and consequently the true income of either parties has not been brought on record. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the relationship between the petitioner and the opposite party number 2 as husband and wife is not in dispute. It is further not in dispute that minor daughter was born, that they have a minor daughter who is residing with the opposite party number 2. This court finds that in the judgment passed by the Honorable Supreme Court in Raziz versus Neha, detailed guidelines have been given with regard to grant of maintenance and interplay of various statutes in connection with the grant of maintenance. This court also finds that in order to streamline the matter regarding grant of maintenance by different courts and it has been, the following guidelines has been issued clearly stating that affidavit of disclosures in terms of enclosure 1, 2 and 3 as may be applicable is required to be given by the parties before the concerned court, and such direction has been made applicable to all the cases which were pending before the court on the date of the judgment, that is 4th of November 2022. Admittedly, the present case was filed prior to the date of judgment of the Honorable Supreme Court, but it remained pending in as much as the impugned order has been passed on 7/5/2022. Considering the aforesaid facts and circumstances, this court finds that the directions issued by the Honorable Supreme Court in the case of Raziz versus Neha has not been complied by the learned family court, which has resulted in allegation and counter allegation, in a claim and counter claim by both the parties, in as much as the petitioner is claiming that he does not have any source of livelihood and the opposite party number 2 has source of livelihood, and on the other hand the opposite party number 2 is claiming that she does not have any source of livelihood and the petitioner has enough source of livelihood to maintain. In such view of the matter, the impugned order, on account of non-compliance of the directions contained in the aforesaid judgment passed by the Honorable Supreme Court, the impugned order cannot be sustained in the eyes of law, which is accordingly set aside. Considering the fact that an amount of rupees 8,000 for the wife and child has been fixed by the learned court below, this court is of the considered view that by taking into consideration the materials which were placed before the learned court below, this court is of the considered view that the petitioner should continue to pay the amount of 8,000 per month to the wife and child as directed by the learned court below by the impugned order by way of interim maintenance till the fresh order is passed by the learned family court after considering the affidavits of disclosure to be filed by both the parties. Such payment would be subject to the final outcome of the decision of the learned family court. The affidavits of disclosure of the petitioner and the opposite party number 2 be filed before the learned family court on March 4th. We'll file it on 4th of March 2024. And the by petitioner and by the parties, upon filing of such affidavits of disclosure in terms of the judgment passed by the Honorable Supreme Court in the case of Neha versus Rajneesh versus Neha, the final decision be passed by the learned family court within a period of 3 months from 4th of March 20. I will just put a few judgments for the guideline of the board, maybe that they are not reading these judgments regarding wife, regarding child, regarding unemployed husband, everything is there. I just put a few, there will be slight modification in the judgment, but this is what the direction is.
Much
Communicate this petition is accordingly disposed of.
Sorry, Rashid,
Where is our other side?
actually, Rashid, I have seen the CME Rashid. All exhibits are not there. Only exhibit 1 and exhibit A are there, Your Lordship. Exhibit 2, exhibit 2/1, 3, 3/1 and 4 are not available.
है? सबका है।
अभी तो दिखाए थे, आप तो बोले कि नहीं है। अभी हम
आपके लिए सारा फ्लैट करके हम लोग रख दिए हैं, काइंडली आप अब आर्ग्यू करें। What assistance more? What more assistance you want from the
बैठ के लॉर्डशिप हम देखे हैं, कोर्ट मास्टर साहब को भी दिखाए थे, नहीं मिला था उस समय लॉर्डशिप।
Just a moment, madam. Just a moment. Right? Firstly, it's your responsibility to see the LCR. Secondly, if you are not able to find it, our office is there to help you, right? But you cannot
I
ask.
asked for the
you
help,
Cannot. You ask for what?
Help, Your Lordship. I asked for the help of the court
So
master.
by the time they could help you, you were not there in the court. Did you ask them thereafter?
In court number 2, the matter is running, Your Lordship. In batch case 1 of my matter is there.
So you go and argue. We had passed it over, but you have come running by saying that
Your Lordship,
LCR is
I
not-
thought ki, last discussion with the court master at 2:25 is that, Your Lordship, ki, 3, 4 annexes are not there, Your Lordship.
You just tell us which all exhibits are not.
Your Lordship, when I saw, Your Lordship, exhibit 2, 2/1, 3,
Do you
3/1,
want to
4
say
were
that that has been added subsequently?
हो सकता है लॉर्डशिप हमसे कुछ गलती हुआ होगा, लेकिन उस समय हमको नहीं मिला।
अब मिल गया? आपको जाना है, आप अपना केस कंप्लीट करके आइए. Because don't argue a case with a split mind. Okay, you go, you just, once you finish, you come. Alright? And in the meantime, you can ask, if you want to see it, you can have a look. Counsel for the stage is also there, right?
Item 38, criminal revision 674 of 2022.
Yes.
Most humbly and respectfully, my lord. Challenge in this case, my lord, is the order dated 9/5/2022, lord, which is standing at annexure 5. Lord, it's a page number 26 to 35. Lord, this is the order, my lord, passed by Chief Judicial Magistrate. By virtue of this order, my lord, my discharge application in terms of section 239 of CRPC, my lord, has been rejected, and it is said that there are sufficient materials available on record to frame the charge Lord, only under section 498A IPC and 3 by 4 of the Dowry Prohibition Act. Lord, the petitioner happens to be the husband in this case. Lord, the allegation, my lord, which has
What
been
is the
made.
present state of the case?
That my lord, Lord, in this case, my lord, there was the stay order. Subsequently, the stay order was vacated, my lord. To be honest enough, my lord, I don't know as to whether the charge has been framed or not. I have only 3 points to canvass before this one.
You argue with this.
Lord, Lord, annexure 1 is the FIR. Lord, according to FIR, my lord, on 3/5/2015, Lord, the marriage between the parties, that is the petitioner and the informant, my lord, was solemnized. It is said 3/5/2015, my lord. It is said that for 2 to 3 months, my lord, both the parties, my lord, lived happily, and thereafter, my lord, there was a demand of additional dowry on the part of the petitioner, which was not fulfilled, and then it is said that she was ousted from her matrimonial home. Lord, she went to her Maike. Lord, petitioner used to visit because at that very point of time, Lord, she was pregnant. But petitioner used to visit, my lord, his matrimonial home to look after the wife. And then, my lord, she has given birth to a.
Petitioner used to visit.
Lord, this is in the FIR itself.
Used to visit the.
His matrimonial home means, my lord, Maike of the informant to look after. But, my lord, it is the complaint on the part of the informant that no financial help was given. And then subsequently, my lord, this petitioner and the in-laws of the informant, my lord, visited the Maike of the informant and assaulted. My lord, no date, no time has been mentioned in the whole of the FIR that if there is any assault, my lord, what was the date on which date, my lord, any specific assault was made or not.
Demand is there?
Right?
Demand of dowry is there?
The additional demand of dowry, my lord, it's said.
That
the
allegation is there?
allegation is there. Lord, the most important thing is my annexure 3. Lord, it's an order of a family welfare committee.
Yes, what is your case? Please tell us.
Lord, it's an order of the family welfare committee dated 22/2/2018. Lord, that is standing at annexure 3. Lord, according to this proceeding, Lord, both the parties, Lord, were called for. Lord, kindly see annexure 3, page number 18. It's a family welfare committee, and it was conducted in the premises of Civil Court, my lord,
When was
Saraikela.
the FIR filed?
Lord, the FIR has been registered, my lord, on 12/9/2017. Marriage is of 3/5/2015. Lord, the parties were sent for family welfare before family welfare committee on 22/2/2018. My lord, I have filed my application for discharge on 3/6/2022. And then the impugned order, my lord, has been passed on 9/5/2022. Now, my lord, before the family welfare committee, my lord, both the parties have appeared, And my lord, discussion was made with the members of the Family Welfare Committee, wherein my lord, it has come that out of some trivial issues, my lord, this case under section 498 had 498A, my lord, had been instituted on the part of the informant, which the informant herself admits.
Defense document, how do we appreciate this?
My lord, why I am saying so? Because my lord, in my discharge petition itself, my lord, I have annexed this order.
That does not.
Lord, at least, Lord, there has to be some judicial application of mind. Lord, that's true, my lord. But your lordship.
This is absolutely your defense document. This is not the statement on oath recorded of the wife.
My lord, that's
Right?
true.
If some order is recorded in this family welfare committee meeting, that does not matter at all. It has got no bearing.
Lord, in
There
case.
is an allegation of demand of dowry.
Lord, in case, my lord.
And there is an allegation that of torture.
My lord, in case, my lord, if I am not able to convince this court, my lord, I beg to withdraw, my lord.
Learned counsel for the parties are present. This petition has been filed for the following relief. After some argument, the learned counsel for the petitioner seeks permission to withdraw this petition and submits that he may be permitted to raise all the points before the learned.
I will be facing trial before the trial.
The learned counsel for the respondent has no objection to the prayer made. Accordingly, this petition is dismissed as withdrawn. Withdrawal of this dismissal of this petition. It will be, however, it will be open to the petitioner to raise all points before the learned trial court at appropriate stages, and dismissal of this case will have no adverse impact upon the petitioner.
I know that.
Item 39, Criminal Division 700 of 2022.
Minutes in this case, I am praying for Passover minutes. This case has to be argued by Senior Advocate Mr. Anil Kumar Kashyap.
What is the matter?
The matter is of reversal minutes. Offence is under section 138 of NI Act. I am complainant minutes. I filed a complaint against the opposite party number 2 for regarding dishonor of the check. In that
Was
minutes,
acquitted?
he was convicted by the Court of Learned Magistrate.
Acquitted by the applicant?
Yes, minutes.
You need to satisfy this court. How is this revision maintained
Yes,
against order of
yes, minutes. I'm aware of that, minutes. There are judgments of Honorable Supreme Court also and a larger bench of this court.
so this is not maintained?
Minutes, I was only praying for Passover minutes.
Yes, I just because I want him to be here, he knows the subject quite well.
And I also minutes because client has engaged me.
Okay, please call him. Right, please continue. Please call him. It is something which has been
Yes,
bothering
yes.
me during the lunchtime
No,
also.
minutes. I'll call.
So
Certainly, I'll call.
yes.
Okay.
That's Mallikarjun judgment
Yes, minutes. And the other bench judgment
of our court.
Yes, minutes. We are having that judgment, minutes. He will be assisting your lordship as well.
We have that judgment. वो उनको कोराई जी को बोलिए वो प्रिंट निकाल के लेके आए थे साथ में मल्लिकार्जुन का जजमेंट और एक जो जजमेंट हम उनको दिए हैं जो लेटेस्ट जजमेंट है वो सारा यहाँ लेके ये पास ओवर हो रहा है.
One Musabba Khatun recent judgment of our court is also there.
So that kind provide that.
Yes,
That is
having-
regarding NI.
Yes. Issue regarding that has been considered and set. It has been settled down. That C78 4 minutes. If offence under section 138 NI Act is there, and complainant is willing to prefer an appeal, then since this is a matter in which complainant is victim, so there is a need of taking leave under section 378 4 of CRPC. And after
Recently there is a judgment of the Supreme Court that she has a right to file appeal as a
Victim.
matter of right.
victim has it
So leave is not required.
in
This
the case.
revision will be converted into.
No, Supreme Court has said that there are two separate set of cases. One is by the victim.
You just have a look at the recent judgments, right? So at least we are on the same point that this is not maintained.
Yes, but
Call
if your
him.
lordship is satisfied, we'll convert it.
Yes.
I'll call my son.
So you never made a prayer. I'm just suggesting
No,
because there is a judgment of the
Since
Supreme
it
Court.
was to be argued by the seniors, so
Please call him.
Item 40, Criminal Division 703 of 2022 along with item 41.
previous petitioner?
I'm OP2 in the first case. It's in the second case.
Maintenance, both the cases? Who is for the husband? You are for wife?
Husband.
Husband, where is the wife? Both of you have filed.
Yes.
Rajnish versus Neha complied.
Yes, I am working in BSF. I have given my this salary details also.
Salary details, you can have additional income also.
Apart from that, there is no additional.
So that is why. That
But
is
that certificate has not been filed in view of the Rajnish.
not being filed. Then why is the wife coming? What is your case? Wife has sufficient income.
No, wife C has willfully left the house. And there was a mediation on the last occasion also. The case was sent for mediation. Being a Jawan in BSF, we do not have this staying with the family facility over there. So I was ready to keep her in a separate house or in a house along with my parents.
We will not go whatever
Yes.
has transpired
Yes.
in me. We will go whatever is available in the records.
But
What is the finding of the learning court regarding this point? Was this point raised or not raised?
which about the lordship? Which
Was this point of 125.4 that she had no justified reason to leave the matrimonial home?
it has come in the deposition also that his father says that we have taken her from the house.
That is another point. Did you raise this point before the learned court that she had no reason to leave the matrimonial house and therefore she is not entitled for maintenance? Unless you raise a point, in revision we cannot appreciate it.
Even though your lordship, as per the judgment of the Supreme Court, what has
So
come?
that is on quantum,
Yeah, quantum also.
but you are
Even then-
challenging it on a different ground.
Yeah. No, that ground is also there. That
Where is that ground?
quantum is also very high. Until today, we have paid her the amount that is in the record.
14,000, quantum is high.
Yes,
What
because
is your salary?
23,000 I am getting after deductions. And the thing is, in ladyship, I have never tried to drive her away from the house.
That is separate. You have to take a specific leave to that point. Where is the salary slip? Where is the discussion regarding quantum of maintenance?
I'll just point it out. I have also annexed it as an Annexure 2. My salary slip is there.
You must have exhibited it.
Yeah,
before.
yeah, that is there. That has been discussed in paragraph number.
Is this the same exhibit?
Yes, yes. That is at paragraph 18 of the judgment, which is at page number 49 of this revision.
No places.
Yes.
So I'm relying upon the second case.
What have you annexed?
That is the salary slip, but it has been discussed in para 18 of the.
Where is the salary slip?
That is Annexure 2. Page number 28. In para 28, para 18 of the judgment, it has been also discussed.
You just come to page number 28.
Yes.
So your take home salary is 23,460.
Yes.
So you want to say this 23,460 out of this 14,000 is payable?
Yes.
That is income. Now you come to the bottom.
So I've just seen again it.
मेरी आँखें बहुत तेज हैं.
But this one,
My eyes are very
but this
sharp.
one, this has
You
been
cannot get away with
no, no,
this.
this has been discussed in
I
paragraph
do
18.
not know. After this deduction it is 23,000.
No, Your Lordship, in page this before passing the maintenance order only.
I don't know.
In page.
This is the document. Your document.
Yes, Your Lordship.
Your salary slip.
Yes.
Now you are, after all deductions, you have taken so much of loan, EMI, everything has been considered, and then this 23,460
This has been issued in 23.
I do not know. You have
And-
annexed it.
Yes, Your
It's
Lordship.
your document.
But upon the document which was earlier, which was before
We
the
do
court.
not know. You firstly, in revision, you cannot introduce a new document.
No, no, I'm not relying on that.
What do you mean you have
In-
not
in
annexed
pen-
it?
No, no, I'm saying, Your Lordship, in paragraph
No,
in
no.
paragraph 18 of the judgment, it has
No.
been decided, discussed about the salaries
No, no.
there. May I permitted to read
No,
that?
no.
In
What-
that, his salary
He is not paying, your lordships.
Yes, sir, you are agreed by the fact that he is not paying.
He's not paying also, and for enhancement also I have filed.
What enhancement? How much did you claim?
totally a false statement.
How much
2,90,000
did
has
you
been
claim?
paid.
Before your lordship, trial court lordship, she has claimed for 30,000, your lordships. $20,000, your lordships.
Out of 20,000, you have got 14,000.
Yes, your lordship. And 10,000 she has paid for her minor child, your lordships. But total she's getting 14. Matlab she has been allowed for 14,000, but she is not getting, your lordships, any.
So she is
money.
not getting his another rate.
Yes,
No, no.
other thing, your lordship.
That is totally wrong. We have paid 2,90,000.
Yeah, that is
She
another
is
thing.
not getting, you have an execution.
Yes, your lordship, she has filed for execution also.
So therefore, what is your case?
Yes, so 20,000 for 20,000 I was paying because he has deductions. His salary is 51,000, and after deductions, your lordship, this salary is there, and for his lavish things or for loan or for anything, your lordships, she is also.
Is it your case that she has other sources of income?
So she is staying with her parents with her own will. I am ready. I have in the before the honorable court also in the depositions also it has come that I always wanted to keep her. Just because I am working in BSF, I cannot keep her with me.
Show
She has
from
said that
the-
I cannot live with my parents.
Where is your show cause file?
But that is not on record LCR. LCR may be called for election so that it can be decided on that.
But the impugn order is not reflecting anywhere. There is no whisper in the impugn order regarding this.
Because it is coming for the first time for hearing leadership, LCR may be called for so that on the next date we are ready with all those facts. All leadership that has been the queries of the leadership.
You all have done master's degree in judgment. I must say this. Show me one of the grounds, only one ground that you were always willing to keep her, but she did not.
I'll
Show me
highlight.
one ground from this. You have drafted it. Herself desert. So as it is, you are not able to keep her
Hmm.
in your place of posting.
Yes, because
So why do you want to keep her in a separate house?
Hmm.
If she is
no, that was her demand. I am ready to keep her in my house also. But she has said that कि मेरे parents के साथ इनका नहीं बनता है, so she will not be staying there. So we have given her an option that you stay at my place, which I am staying in Bengal. But she says नहीं हमको अपने घर. She is from Nirsa Dhanbad, so she wants to stay there.
So what is your problem about it? As it is, you are not.
No,
staying
she is claiming that 14,000 as maintenance plus 20,000 extra.
You forget about the claim.
Yeah.
So your case that you want to keep her cannot be.
I am ready to keep her even today. I am ready to keep her separately also. But she is
When you keep her separately, you will incur additional expenses, no?
because she is not ready only to live with my parents. That is the difficulty.
Yes, then the matter may be sent to mediation. She's not not saying me to.
Because
that
in the
she
cross
will
examination
decide
also it has
what-
come. She has said, I think
Are you
yadi
interested in mediation?
we are ready, Your Lordship. Last time also we have tried. We have
Mediation has
our
failed.
first case. We have tried to keep.
Mediation has failed.
Yes, yes.
It was sent for mediation.
His Lordship, regarding that mediation, I don't have information, but now she is
First
saying
case
that
was sent
he
for
is not
mediation.
keeping her, and neither he want to give her full maintenance, Your Lordship.
The mediation report is a very recent report.
Yes, yes. It was about to be resolved, but at the last moment there were some demands which we could not complete. And regarding the payment, Your Ladyship, it is there that we have paid her 2,90,000 already till today.
Good for the lifetime.
No, I am not saying that it is good. I am saying that I am adhering to the order of the court. And I am ready to keep my family because there is a child who is dependent on me.
Now he is 6 years old, Your Lordship, and son is of 6 years old, Your Lordship, and expenses.
498A case is also pending.
Yes, that is also.
So how will she come and live with him?
So that's why there were.
She has got all reasons not to live.
No, a main allegation is that she cannot leave because when I'm at my duty, she has some quarrel with the family members.
Then a criminal case is pending. There is no question of she has got all the reasons not to live.
Lordship, that is still for adjudication. The charges are still, I am not convicted in that matter.
Maybe you are not convicted.
Because there is not a single allegation against me.
Cruelty, you want her to be subjected to live
There
in
are-
an environment where she is always under an apprehension of cruelty.
That's why I have also decided to keep her separately. But the only thing is that had it been that I was not in the central forces, I would have stayed somewhere else. I could have kept her with me.
In spite of, it is none of your case that she has any additional source of livelihood. Is it your case?
No, we have not.
She also does not have any case that he has additional source of livelihood.
No. Dependent child is there, Your Lordship, of 6 years old child, Your Lordship.
You get the child admitted in school and you file your application under section 127. Because that will be a subsequent development.
Yes, Your Lordship.
Additional, you are basically saying that there is an additional expenses which is coming up.
Yes, Your Lordship.
Right? So you file a
A
petition.
liberty maybe, Your Lordship, there is
Liberty
liberty,
is
there is
always
provision, Your Lordship, there is provision, but Your Lordship may give her short liberty, then it
No,
will be helpful.
liberties, I will simply say that for subsequent development, you have a remedy under law, but not in revision application. No case made out. In spite of that, when there is no dispute regarding husband and wife, when there is no dispute regarding sources of
Ladyship,
income.
we have tried our best to keep. There are instances we have been on both the sides when parties are not ready. Even I had impressed upon my client to do all sorts of things, but the demands were getting elevated time to time. That's why.
Where is the wife living?
With her parents, Your Lordship, she is living with her parents.
Have you talked to your client?
Yes, Your Lordship.
Does she want to settle the disputes?
Now it's not possible, settlement is not possible, but mediation, I was saying that some settlement for final settlement for separation also maybe.
You are interested in separation. What is your age? You have a child?
Yes, she is at 26 years of age, she is.
You want a separation?
Just because of cruelty, Your Lordship, she don't want to get separated, but
What is the nature of cruelty? What happened?
with her in-laws, she was residing with her in-laws, Your Lordship.
So in-laws had committed some.
Yes, Your Lordship.
What about the husband?
Husband was not residing with her because he was at
He
his
was not
post.
there, so there is no allegation against the husband, isn't it?
But he was not taking care of her, Your Lordship. Due to that reason, Your Lordship, she was
Husband
getting
is also
tortured.
an accused in 498A.
All the family members.
Yes, Lord, she is also an accused.
Madam, please do some social work. and try. It appears that this matter can get settled.
Your Lordships, then one adjournment may be given to my Lordships.
Ask them to join online, right?
Yes.
And we will figure out if they are willing for settlement. Then we will send for mediation.
Yes.
Because without consent we cannot send for
Yes,
mediation.
Lordship.
And mediation also can be conducted online. There is no problem.
Yes, Lordship.
When can they join?
She is she is residing in her house. She is not doing nothing. Any date may be fixed as per his convenience.
Anytime. Any date. Next week, Monday,
Monday?
4:15
Online? 4:50?
Not as 4:15 P.M.
The learned counsel for the parties are present. The petitioner in criminal division number 703 of 2022 is wife and has a child and has a minor girl child.
Yes, boy.
Boy, 6 years.
Minor boy child who is 6 years of age. The opposite party number 2, the husband, is in argument. During the course of argument, the records reveal that the matter was sent for mediation, but it remained unsuccessful. However, considering the nature of dispute and the arguments by the parties, it appears that the matter can still be resolved through mediation. But before sending the parties for mediation, it would be appropriate that the parties should appear through online before this court. Right? Pose this case on Monday, the parties to join online at 4:50.
Much.
Item 42, criminal revision 735 of 2022.
She was convicted under section 138. Both the courts have given a concurrent finding holding the conviction of section 138. But the sum amount of the check was 5 lakh rupees and the punishment awarded is 5 lakh plus 5 lakh rupees in compensation plus 6 months of imprisonment. Plus in the course of argument, we had filed before the one IA for suspension of sentence. Now on condition of deposit of 1 lakh rupees, we are given the privilege of suspension of sentence. So now we are at the admission stage. Now leadership, if my prayer is seen, my prayer is we have made impugned only the order passed by
You will
the
give it suspension of sentence or
no
exemption from-
I was taken into custody. And now on condition of deposit of sum of rupees 1 lakh, I was given this privilege of suspension of sentence.
What is the perversity in the impugned order?
Yes, Manas. The first primary ground which I would like to press on is the Manas that the conviction was totally set upon on the principle of presumption. Presumption, leadership section 118 and 139 of the Negotiable Instruments Act. Because it was my case that since the very inception, that is since the receipt of the legal notice, we had made this particular stance in session that these checks were nowhere presented to the complainant. These checks were given to my son, and we had categorically denied that how did this fell into these arms of the complainant. And then again, there was no legal liability, there was no enforceable liability against which this check was given to the complainant. But that reply to the legal notice was also adduced as a evidence before the magistrate, the first court. Now, leadership, if we start from the first order, the first court, whereunder the entire evidence and my
Your signature is admitted?
signature is admitted. There was a signature, but then again, it was.
Did you respond to the legal notice?
Yes.
What was your response?
We responded stating that the same what I have stated that
Where is that?
leadership that has come in the first court's order by the entire and the exhibit. It was also exhibited. By,
Must have been.
yes, ma'am.
But where is the discussion?
Discussion is in the first order. If the
अंकुर सीड्स कंपनी रांची से इनका नकदी उधार लेन देन होता रहता है.
that was my case that I had given this by way of security to one Ankur Seeds and it was given to my son. Then I did not believe that how come this check gets landed upon in the complaint.
A blank check to Ankur Seeds.
No, not to the Ankur Seeds, to my son.
It was
To be given to the Ankur Seeds by my son because I said that I am an
so you
old.
have lodged a criminal case against your son?
That was not wrong, Manoj. That was not. No, here is my yes. So that is why I'm what I'm trying to prove that
Your son has been examined.
my son was also not examined.
So you took up a story.
No, ma'am. What has
Right.
happened? Because I was going through certain judgments of the Supreme Court and all. One is the concept of preponderance of probabilities. This acts both ways. This is one door which swings both ways. So now once I had drawn the attention of the learned court below, giving a rebuttal. So I guess I will try. I had tried to make out a case that the rebuttal. Yes, ma'am. That is what the court has has given.
Rightly so.
But again.
No perversity.
Now that is what the court has come to the conclusion. But I say, basing my arguments upon the judgments, that I had tried to, there needs to be a strict burden of proof on me. Even a preponderance of probability would have turned the case around. Because once I have I've been able to punch a hole in the mind of the court below, the onus would have been fallen on the other side. That is the complainant.
You did not succeed in punching that hole.
Well, that is what that is entirely the what has the observation has made by the court below. So to justify it.
In your 313, what was your explanation?
The 313 I have
Simply denied.
no, I have tried to make out a case. It is not simply denied.
It is simple denied.
Well, it was as per me it was not simple denied. I have tried to make out a case.
Where are you saying it was not simple denied?
That was taken into
The
consideration.
judgment is stating that it is a case of simple denial.
Yes, Manas. If that my examination before the court below, it was there in the and whereby it was the deposition and the cross examination is very lengthy. So it must because the onus was directly upon me. Primarily, it was upon me, and then again.
It was the findings of the trial court first.
Yes.
And then we are hearing it finally. We are not going to adjust.
Well, if
Whatever you have to say, you are.
yes. Because leadership, it was also though, but it is doesn't find on the evidence because leadership. All this I have. I do not have with me is the copy of depositions.
We will not reappreciate that deposition.
If I am allowed to read the judgment of the first court. It starts from. Even starting from the beginning. निर्णय इट्सेल्फ अभी अजय कुमार श्रीवास्तव को विचारण धारा 138 एनआई एक्ट के तहत हुआ। परिवादी का केस परिवार पद के अनुसार संक्षेप में यह कि मुद्दे व मुद्दाले एक दूसरे को भली भांति जानते व पहचानते हैं। यह कि मुद्दाले को अपने व्यवसाय हेतु रुपए की आवश्यकता थी जिसके लिए मुद्दाले ने मुद्दई से विभिन्न तिथियों तो कुल 5 लाख रुपए उधार लिया था। ये कि मुद्दाले ने मुद्दई से ये कहते हुए कि उपरोक्त रुपया उधार लिया था कि 6 माह में रुपया वापस कर दूंगा। ये कि मुद्दाले ने 6 माह से अधिक का समय गुजर जाने के बाद भी मुद्दई को रुपया वापस नहीं किया तो मुद्दई मुद्दाले से उधार लिए गए उपरोक्त रुपये का मांग करने लगा, परंतु मुद्दाले आजकल देने की बात कहकर टाल मटोल करता रहा। ये कि मुद्दाले ने मुद्दई को काफ़ी तगादा के बाद दिनांक 15/7/2017 को पंजाब नेशनल बैंक शाखा लातेहार में स्थित अपने खाता संख्या 7 का एक चेक जिसका नंबर 541081 था जिसमें 5 लाख रुपए का राशि भरा हुआ था मुद्दई के नाम से दिया था। ये कि मुद्दई ने उपरोक्त चेक को दिनांक 15/7/2017 को इलाहाबाद बैंक शाखा लातेहार में स्थित अपने खाता संख्या 10 में जमा किया था ये कि इलाहाबाद बैंक शाखा लातेहार ने दिनांक 17/7/2017 को उक्त चेक अन्य एक दस्तावेज के साथ मुद्दे को वापस कर दिया। ये कि बैंक ने उक्त चेक के साथ एक दिए दस्तावेज के माध्यम से मुद्दे को ये जानकारी दिया है कि मुद्दाले के उपरोक्त खाता में पर्याप्त राशि नहीं होने के कारण उपरोक्त चेक का भुगतान नहीं हो सका तथा चेक अपयश हो गया है। यह कि मुद्दे ने जब उपरोक्त सारी घटना की जानकारी कई बार मौखिक रूप से मुद्दाले को दी तो मुद्दाले ने मुद्दे के साथ अभद्र व्यवहार किया तथा कहा कि मैं रुपया नहीं दूंगा, जो करना करें। ये कि मुद्दे ने उपरोक्त घटना को लेकर दिनांक 4/8/17 को अपने अधिवक्ता श्री विक्रांत कुमार सिंह के माध्यम से मुद्दाले को वकालतन नोटिस भेजा, जो को मुद्दाले को प्राप्त हो गया था। जिसके बाद मुद्दाले ने अपने अधिवक्ता श्री धीरेन्द्र कुमार शुक्ला के माध्यम से मुद्दे के अधिवक्ता श्री विक्रांत कुमार सिंह को 14/8/17 को निबंधित डाक के माध्यम से उक्त वकालतन नोटिस का जवाब भेजा था, जो कि मुद्दे के अधिवक्ता को 16/8/17 को प्राप्त हुआ, परंतु मुद्दे किसी अन्य कार्य अपने व्यवसाय हेतु बाहर गया था, जिस कारण मुद्दे को उपरोक्त जवाब की जानकारी दिनांक 28/8/17 को हुई। मुद्दे जवाब पढ़ते ही अचंभित हो गया। ये कि उपरोक्त वाक्य के मुद्दाले ने आज दिनांक 5/6/17 तक मुझे उक्त चेक जिसका नंबर सचिन था, जिसमें 5 लाख रुपए का राशि भरा हुआ था, जो पंजाब नेशनल बैंक शाखा लातेहार का था, कि राशि का भुगतान नहीं किया है। यह कि मुद्दे उपरोक्त शिकायत आवेदन के साथ उपरोक्त चेक बैंक द्वारा अज्ञात अपेश प्रमाण पत्र व निबंधित डाक की पर्ची तथा मुद्दालय द्वारा भेजा वकालत नोटिस के जवाब का मूल प्रति और वकालतन नोटिस की छायाप्रति दाखिल कर रहा है। ये कि वर्तमान में मुद्दे की आर्थिक स्थिति काफ़ी दयनीय हो गई है तथा मुद्दालय के बर्ताव एवं उसके भेजे गए जवाब से मुद्दे काफ़ी आहत है एवं अपने आप को ठगा सा महसूस कर रहा है। उपरोक्त आशय की लिखित सूचना परिवादी ने श्रीमान मुख्य न्यायिक दंडाधिकारी लातेहार को दिया। श्रीमान मुख्य न्यायिक दंडाधिकारी लातेहार ने उक्त बात को अनुमंडल न्यायिक दंडाधिकारी लातेहार को स्थानांतरण किया। अनुमंडल ने दिनांक 18/17 को अध्यक्ष अजय कुमार श्रीवास्तव के विरुद्ध एनआई एक्ट की धारा 120 के अंदर संज्ञान लिया गया। दिनांक 8/12/17 को अभियुक्त के विरुद्ध अभियोजन का सारांश सुनाया गया। दिनांक 20/12/17 को अभियुक्त का बयान धारा 313 के अंतर्गत अभिलिखित किया गया, जिसमें अभियुक्त ने अपने आप को निर्दोष तथा परिवादी साक्ष्यों के साथ मिथ्यापूर्ण बताया। अब न्यायालय के समक्ष मुख्य प्रश्न यह है कि क्या परिवादी अपने वाद को अभियुक्त के विरुद्ध युक्ति युक्त पूर्ण संदेहों से परे साबित करने में पूर्णतः सफल रहा है। मंतव्य परिवादी अपने वाद में समर्थन 2 साक्ष्यों का साक्ष्य न्यायालय में प्रस्तुत किया गया है। मतलब फर्स्ट इज द कंप्लेंट कौशल कुमार सिंह, परिवादी संख्या 2 इज अनिल कुमार सिंह, and these are the following exhibited documents. Now the discussion of evidence is next with what follows. परिवादी संख्या 1 that is कौशल कुमार सिंह, इन्होंने अपने मुख्य परीक्षण में बताया है कि मैंने ये वाद मुद्दाले श्री अजय कुमार श्रीवास्तव पिता स्वर्गीय राधा मोहन लाल पिता शिव मंदिर के सामने बाजार टान मुख्य प्रत ग्राम व पोस्ट लातेहार थाना व जिला लातेहार राज्य झारखंड पे किया है, जिसे मैं भली भांति जानता व पहचानता हूँ। मुद्दाले ने मेरे से अपने व्यवसाय हेतु विभिन्न तिथियों को कुल 5 लाख रुपया उधार लिया था। मुद्दाले ने मेरे से ये कहते हुए उपयुक्त रुपया उधार लिया था कि 6 माह में सारा रुपया वापस कर दूंगा। यह कि 6 माह के पश्चात मुझे रुपये की आवश्यकता पड़ी तो मुद्दाले से उपयुक्त रुपये की मांग किया था, लेकिन मुद्दाले ने यह कहा कि 1-2 दिन में रुपया वापस कर दूंगा, कहकर हमेशा टाल मटोल करते रहे। ये कि काफ़ी तगादा के बाद मुद्दाले ने दिनांक 15/7/17 को पंजाब नेशनल बैंक शाखा लातेहार में अपने सदन एक चेक जिसका नंबर इतना था, जिसमें 5 लाख रुपये का राशि भरा हुआ था, मेरे नाम से दिया था। मैंने उपरोक्त चेक को दिनांक 15/7/17 को इलाहाबाद बैंक शाखा लातेहार में स्थित अपने खाता संख्या में जमा किया था। यह कि इलाहाबाद बैंक शाखा लातेहार ने दिनांक 17/7/17 को चेक अन्य एक दस्तावेज के साथ मुझे वापस कर दिया। ये कि बैंक ने उक्त चेक के साथ दस्तावेज से मुझे ये जानकारी दिया था कि मुद्दाले के उपरोक्त खाता में पर्याप्त राशि नहीं होने के कारण उपरोक्त चेक का भुगतान नहीं हो सका तथा चेक अपयश हो गया है। ये कि जब उपरोक्त सारी घटना की जानकारी कई बार मौखिक रूप से मुद्दाले को दी तो मुद्दाले ने मेरे साथ अभद्र व्यवहार किया तथा कहा कि मैं रुपया नहीं दूंगा, आपको जो करना करें। मुद्दाले के उपरोक्त व्यवहार और घटना को लेकर दिनांक 4/8/17 को मैंने श्री अधिवक्ता सुविधा से वकालतन नोटिस भेजा, जो मुद्दाले को प्राप्त हो गया। इसके बाद मुद्दाले ने अपने अधिवक्ता से मेरे अधिवक्ता को 14/8 को निबंधित डाक के माध्यम से उपवाला नोटिस का जवाब भेजा था, जो मेरे अधिवक्ता को 16/8/17 को प्राप्त हो, परंतु में किसी अन्य कारण से व्यवहार के कारण मेरे अधिवक्ता ने मुझे उपरोक्त जवाब की जानकारी 28/8 को भेजा था और मैं जवाब पढ़ा तो मैं अचंभित रह गया। मैंने मुद्दाले के अधिवक्ता को भेजे कर न्यायालय में दाखिल किया, जिसमें पहचानता हूँ। उपरोक्त वाक्य के मुद्दाले ने आज तक मुझे उपरोक्त चेक की राशि का भुगतान नहीं किया। मैंने उपरोक्त शिकायत बाद आवेदक के साथ उपरोक्त चेक का मूल प्रति न्यायालय में दाखिल किया था, जिससे मैं पहचानता हूँ। उपरोक्त चेक पर मुद्दाले अजय कुमार श्रीवास्तव का हस्ताक्षर है, जिसे पहचानता हूँ। मैंने उपरोक्त शिकायत व आवेदन के साथ दिनांक 8/3/16 को इलाहाबाद बैंक शाखा लातेहार द्वारा निर्गत अपयश प्रमाण पत्र मूल प्रति न्यायालय में दाखिल किया था, जिसे मैं पहचानता हूँ। उक्त प्रमाण पत्र शाखा प्रबंधक का लघु हस्ताक्षर है, जिसमें पहचानता हूँ। मैंने उपरोक्त शिकायत बाद आवेदन के साथ निबंधित डाक की पर्ची की मूल प्रति दाखिल किया, जिसमें पहचानता हूँ। पारा 10 में प्रतिवादी अपने वकील के माध्यम से जो जवाब भेजे थे उसमें प्रदर्शन अंकित किया जाता है। ये वही चेक इसका जिक्र पारा 12 में है, जिसे पहचानते हैं। जिसे प्रदर्श 2 अंकित किया जाता है, जिसे प्रदर्श 2 किया जाता है। इसमें अजय कुमार श्रीवास्तव का हस्ताक्षर है। पैरा 14 में बैंक का सर्टिफिकेट, जिसे प्रदर्श 3 अंकित किया जाता है, जिसमें पंजाब नेशनल बैंक के मैनेजर का हस्ताक्षर। पैरा 15 में रजिस्ट्री रसीद को प्रदर्श 4 अंकित किया जाता है, जिसमें 16 में लीगल नोटिस प्रदर्श 5 अंकित किया जाता है। पैरा 17 में शिकायत पत्र को प्रदर्श 6 अंकित किया जाता है। इन्होंने अपने प्रतिरक्षण में पैरा 21 में बताया कि उन्होंने चेक में केवल हस्ताक्षर कर दिया और कहा कि बाकी रुपया आप भर लेंगे। नाउ सेकेंड, परिवादी साक्षी संख्या 2 अनिल कुमार सिंह। इन्होंने अपने मुख्य परीक्षण में बताया है कि उपयुक्त शिकायतवाद कौशल कुमार सिंह पिता ब्रजेश कुमार सिंह अम्बाकोटी बाजार थाना जिला ने अजय कुमार श्रीवास्तव पिता स्वर्गीय राधा मोहन लाल पता श्रीमती पोस्ट लातेहार जिला झारखंड पे किया है। मैं इस बात के दोनों पक्ष को पहचानता हूँ। यह कि बात के मुदाले ने मुद्दे से अपने व्यवसाय हेतु 5 लाख का रुपया उधार लिया था। ये कि मुदाले ने मुद्दे से कहते हुए कि उपयुक्त सारा रुपया उधार लिया था, 6 माह में वापस कर दूंगा। 6 माह पश्चात मुद्दे की आवश्यकता पड़ी तो मुद्दे ने मुदाला को रिपीट्स द सेम थिंग। ये कि मुदाले ने उपरोक्त व्यवहार घटना विवेच कर अपने अधिवक्ता के माध्यम से मुदाले को वकालतन नोटिस भेजा था, जिसके बाद मुदाले ने अपने अधिवक्ता के माध्यम से मुद्दे को अधिवक्ता को निलंबित डाक से माध्यम से उक्त वकालतन नोटिस का जवाब भेजा था। ये कि उपरोक्त व्यवहार के मुदाले ने आज तक मुद्दे के उपरोक्त चेक की राशि भुगतान नहीं किया। उन्होंने अपने प्रतिपक्ष पार 21 में बताया कि कौशल अंकुर बीज दुकान रांची में काम करता था और मुदाले का पुत्र श्रीधर सिक्योरिटी के रूप में चेक कौशल अंकुर बीज दुकान में जमा करने हेतु दिया था। दैट इज द लाइन, लास्ट लाइन मानस। नौ, परिवादी के ओर से 2 साक्ष्यों के साथ न्यायालय में प्रस्तुत किया गया है। परिवादी संख्या 1 कौशल कुमार सिंह। इन्होंने अपने साक्ष्य में बताया है कि मुदाले को व्यवसाय हेतु उन्होंने विभिन्न तिथियों में 5 लाख रुपया उधार दिया था। मुदाले मुद्दे को 6 महीने सारा पैसा लौटाने का वादा किया था। मुदाले ने मुदाले से 6 महीने बाद पैसा मुकाबला करने लगा। काफी तगादे के बाद मुदाले ने दिनांक 15 से 17 को पंजाब नेशनल बैंक शाखा लातेहार में स्थित खाता संख्या का एक चेक संख्या इतना है, जिसमें 5 लाख रुपए का राशि भरा हुआ था, मुद्दई के नाम दिया। उक्त चेक को मुद्दे ने दिनांक 15/7 को इलाहाबाद बैंक शाखा लातेहार में अपने खाता संख्या इतना में जमा किया। दिनांक 17/7/17 को उक्त चेक को अन्य दस्तावेज के साथ मुद्दई को वापस कर दिया गया। बैंक ने के उक्त चेक के साथ दिए गए दस्तावेज से मुद्दई को पता चला कि मुदाले के खाते में पर्याप्त राशि नहीं होने के कारण उपरोक्त चेक की भुगतान नहीं हो सका तथा चेक अपयश हो गया। इस घटना की जानकारी मुद्दे ने जब मुदाले को दिया तो मुदाले ने मुद्दे के साथ अभद्र व्यवहार किया, बोला कि रुपया नहीं दूंगा, जो कहना करी। इस घटना संबंधी मुद्दे दिनांक 4/17 को अपने अधिवक्ता से विक्रांत कुमार सिन्हा से माध्यम से नोटिस जिसको मुद्दा ने प्राप्त किया। बाद में मुद्दा अपने से मुद्दे के अधिवक्ता श्री विक्रांत कुमार सिन्हा को 14/17 के निबंध डाक के माध्यम से मुद्दे का जवाब भेजा, जिसे मुद्दे ने अधिवक्ता दिनांक 16/17 को प्राप्त किया। मुद्दे के अधिवक्ता मुद्दे की जानकारी 28/8 को दिया। मुद्दे जब पढ़ा तो अचंभित रह गया। अधिवक्ता के जवाब के माध्यम से मुद्दे को भेजा। प्रदर्श 1 चेक प्रदर्श 2 बैंक के सर्टिफिकेट प्रदर्श 3 रजिस्ट्री को 4 लीगल नोटिस को 5 शिकायत पत्र को 6 अंकित किया। वादी संख्या 2 अनिल कुमार सिंह, इन्होंने शासकीय सदस्य पक्ष में साक्ष्य पूर्ण समर्थन किया है। वादी की ओर से निम्नलिखित प्रदर्श न्यायालय में दाखिल किया गया है। प्रदर्श 1 वकालतन नोटिस का जवाब। इस प्रदर्श में वकालतन नोटिस श्री धीरेन्द्र कुमार शुक्ला अधिवक्ता ने व्यवहार न्यायालय लातेहार ने श्री विक्रांत कुमार सिंह अधिवक्ता को भेजे हैं, जिसमें मुवक्किल का नाम श्री अजय कुमार श्रीवास्तव पिता स्वर्गीय राधामन पता शिव मंदिर के संग बजाटा मुख्य पद जिला लातेहार अंकित है। इस प्रदर्श में ये भी अंकित है कि दिनांक 15 से 17 को पंजाब नेशनल बैंक शाखा लातेहार खाते संख्या इतना में जिसका चेक संख्या इतना, इसमें 5 लाख रुपया भरा हुआ राशि दिया हूँ। आपके पास उपरोक्त नंबर का चेक कैसे वो किस माध्यम से पहुंचा इसके बारे में बिल्कुल अनजान हूँ। साथ ही चेक में भरे हुए राशि, तिथि व नाम की जांच व इंक की जांच फिंगरप्रिंट एक्सपर्ट से कराकर पूर्णतः सत्यता की जांच की जा सकती है। अतः आप गलत मंशा रखते हुए रची रचाई साजिश के तहत मेरे मुवक्किल को फंसाने का प्रयास कर रहे हैं। इनके द्वारा ये भी जिक्र किया गया है कि मुवक्किल इनके ऊपर गलत इल्जाम किया गया है। मैंने व्यवसाय हेतु किसी भी प्रकार की राशि का लेन देन नहीं किया है। इनके इस नोटिस में ये भी उल्लेख है कि आपके गलत इरादे को पूर्णतः बखान करता हूं कि आपने किस प्रकार किसी माध्यम से प्राप्त चेक का दुरुपयोग करने का प्रयास किया है। जब तक आज तक मैंने उपरोक्त खाते में इतनी बड़ी रकम के साथ लेन देन नहीं किया है। मेरा व्यवसायिक संस्थान छोटा मोटा बीज और कृषि से संबंधित दवा बिक्री केंद्र है, जहां इतनी राशि का लेन देन करना बिल्कुल yes,
But that is not your case.
well, it was
You said that it was given in a transaction.
it will come further, Manoj. It shall come further. It has come in my
See, at the first instance when you responded,
yes.
you simply denied the issuance of check.
I stated that I am surprised of the fact that how did this check landed in your possession, and I doubted that it was never issued in your name.
No, you said that it was never issued.
Yes. It was never issued in the name in the favor of the
It
complainant.
was never issued at all. This was your reply. Exhibit 1.
And
There is no such story which you are trying to raise before this court
So
now.
that shall come further.
No. At the first instance.
At the
when
first
you
instance,
respond,
while replying to
at
that
the end
legal.
of the story, where is the question of reappreciation of this fact?
No, but then again, madam, the preponderance of probability would only be this would.
Merely because you say that there is no debt and there is no relationship, that does not mean that
Yes, madam.
the presumption will get rebutted.
That presumption under section
Show
1.
me some judgment on this. That merely because the accused says that there is no
There's-
relationship.
Mere just denial would not suffice, madam. That is what also Supreme Court says. It also uses the same sentence. Mere just denial of facts would not just suffice. But instead, it should be the one what the line Supreme Court was, if I'm allowed to raise this.
And he is explaining under what circumstances the check was given.
Yes.
It is not a case that he is not explaining the
Then it was-
relationship.
This explanation
you know
would.
each other, both of you, right? He says that there was a loan transaction, a friendly loan transaction.
Well, this fact that I have and the complainant were known, it is never admitted by this accused, this petitioner before my lord.
The complainant was not known to you.
Because if further the cross examination, if I have given a liberty further, I'll read all the cross examination and the evidences which was done to the complainant. Now the preponderance of probability would also lie on the complainant to establish a legal, at least some of the liability against which the check was issued. Well, paragraph 15 to 25 is where this honorable court has dealt with this issue.
Yes.
Melody in criminal appeal, para 18 to.
I have not yet come.
Before we, this is my submission that before we come to the judgment of the Supreme Court, like if you are done reading, because the judgment and the deposition of the complainant, they are the only three evidences: the deposition of the complainant, accused, and the findings of the court. This would be the necessary. And then if I can try to satisfy the court that whether this.
You have the deposition with you, no?
Minus, I have the deposition of the complainant.
So how do you say that? What was the deposition? Of
313. I was put a query that 313 deposition, because I have given out, because it is the only copy
You see, I
that.
am not inclined to call for the LCR. There
Yes.
is a concurrent finding and full discussion of every aspect.
But there must be, but then again, that is where my case also lies. That if the law is not be discussed in a proper aspect, then
Law is
there could only be that.
discussed in a very
Because it is the duty of the court below to take at least 139, because it is only the presumption part. And my conviction is also based on the presumption part.
Para 18 to 22 of the include order of the criminal appeal. इसमें जजमेंट्स के बारे में सारा कुछ दिया हुआ है, कंक्रीट फाइंडिंग के साथ मतलब ऑर्डर हैज ऑलरेडी बीन पास्ड. And provisional bail was also granted by the court lordship की 1 लाख रुपया दीजिए और जमा provisional bail ले लीजिए.
That is while
Until
exercising the
no
discretion.
amount has been given lordship.
Well, if I
And
am
he
allowed to pay.
and he is enjoying the privilege of bail lordship, provisional bail.
Now, if I'm allowed to read paragraph 7 orders at page 9 of the first court's order, that is where my deposition comes.
Page 9.
Yes, paragraph 7 order. मुदाले की ओर से एक साक्षी का साक्ष्य न्यायालय में प्रस्तुत किया गया है. That is अजय कुमार श्रीवास्तव was the accused. मुदाले की ओर से निम्नलिखित प्रदर्शन न्यायालय में दर्शन किया है. डॉक्टर शेखर सिन्हा का डॉक्टर का पर्ची कृषि विहार के लेटर पैड में डायरेक्टर अंकुर कंपनी को लिखे गए पत्र. विपक्षी साक्षी संख्या 1 अजय कुमार श्रीवास्तव, इन्होंने अपने मुख्य परीक्षण में बताया है कि इस बात के मुद्दे को वो ना पूर्व से जानता था न पहचानता था. जब वकालतन नोटिस प्राप्त हुआ तब मैं परेशान हो गया तथा मुद्दे के बारे में जाना. मैं कौशल कुमार सिंह से कोई भी रुपया कर्ज नहीं लिया हूँ, बल्कि मुझे मेरे बेटे से मालूम हुआ कि अंकुर सीड्स कंपनी का कार्यालय रांची में यह काम करता था तथा मेरे बेटे श्रीधर श्रीवास्तव के साथ जान पहचान था. जब अंकुर सीड्स कंपनी रांची मैं कौशल कुमार सिंह से कोई भी रुपया कर्ज नहीं लिया हूँ, बल्कि मुझे मेरे बेटे से मालूम हुआ कि अंकुर सीड्स कंपनी का कार्यालय रांची में ये काम करता था तथा दी कंप्लेनेंट ये काम करता था तथा मेरे बेटे श्रीधर श्रीवास्तव के साथ जान पहचान था.
So there was some kind of relationship, maybe a friend or known at least through the son.
That is when the notice was
Not
given to
he
me.
used to work.
No, the son used to work.
Son used to work. So he is not totally an alien person.
साथ जान पहचान था ना. एंड दिस पर्सन यूज्ड टू वर्क इन, मालूम कि अंकुर सीड्स में कंपनी काले में ये काम करता था. मींस द कंप्लेनेंट यूज्ड टू वर्क इन अंकुर सीड्स एंड दैट इज हाउ वेयर ही वाज नोन टू हिज सन. एंड देन आफ्टर गेटिंग दिस नोटिस ही केम टू नो अबाउट दिस फैक्ट. नाउ फर्दर इट सेज लिबर्टी रेट फॉर जब अंकुर सीड्स कंपनी रांची से मेरी नकदी उधारी लेन देन होता था, मेरा बेटा श्रीधर श्रीवास्तव 5 सिक्योरिटी चेक अंकुर सीड्स कार्यालय में जमा करने हेतु विश्वास में दिया और उसी में से एक चेक को बदमानी करने की नीयत से मुझे कौशल कुमार सिंह 5 लाख रुपए ईटने के लिए ब्लैकमेल कर रहा है. यह कागज डॉक्टर शेखर सिन्हा, दुर्गा मंदिर, रातू रोड, रांची का जांच प्रिस्क्रिप्शन है जिस पर डॉक्टर साहब का लघु का हस्ताक्षर है.
जब अंकुर सीड्स कंपनी रांची से मेरा नकद उधारी का लेन देन होता था.
Yes.
So the complainant had also full relationship with the Ankur Seeds, right?
Yes.
And there was a transaction regarding cash loan etc. है ना? ये बेटा श्रीधर 5 सिक्योरिटी चेक अंकुर सीड्स के कार्यालय में जमा करने हैं, राइट? या उसी में से एक चेक को बेईमानी करने की नियत से 5 लाख रुपए करने हैं. So issuance of check is not in dispute.
Issuance of check is not in dispute.
Not in dispute, but you denied issuance of check in the reply to the legal notice.
I denied issuance of check to the complainant.
No, you denied it completely. You said that it should be sent for handwriting expert and whatnot.
No.
You never said that it is like
Handwriting to handwriting expert because he says that it was signed, but then again the other particulars were filled up by this complainant and presented before the. If I read further, ये कागज डॉक्टर ऐसे कैसे 5 इतने के लिए ब्लैकमेल कर. दिस इज व्हाट इट सेज. फर्दर ही सेज ये कागज डॉक्टर शेखर सिन्हा, दुर्गा मंदिर रोड, रातू रोड, रांची का जांच प्रिस्क्रिप्शन है जिस पर डॉक्टर साहब का लघु का हस्ताक्षर है और प्रिस्क्रिप्शन उन्हीं की लिखावट एवं हस्ताक्षर में है. यह केवी कृषि विहार अर्थात मेरी दुकान का लेटर में टाइप किया हुआ रिक्वेस्ट लेटर है. रजिस्ट्री स्लिप का फोटो कॉपी है जो श्रीधर श्रीवास्तव द्वारा दिल्ली से व्हाट्सएप में भेजा गया है. कौशल कुमार सिंह का केस पूरी तरह झूठा है. धोखाधड़ी का केस श्रीधर श्रीवास्तव द्वारा शिकायत पत्र रजिस्ट्री द्वारा लातेहार थाना एवं एसपी लातेहार को भेजकर मुद्दई के विरुद्ध किया गया है. उसका फोटोकॉपी है. मुद्दई का आरोप पूरी तरह झूठ एवं लालच तथा बेईमानी पर आधारित है.
Who has filed this criminal case?
The son. Not it was not criminal case. It was intimation given to the thana, concerned thana. This was what it means.
He has not been examined.
No. Further, if I come to 8 because this talks about his son Shridhar Srivastava, but then again further it will come to know that it has not been examined. Now, डॉक्टर शेखर सिन्हा का पर्ची है जिसमें प्रदर्श ये अंकित किया गया है. कृषि विहार के नाम से अंकुर कंपनी के डायरेक्टर को लिखे हैं जिसे प्रदर्श भी अंकित किया गया है. कौशल कुमार के नाम से शिकायत किया एसपी का उसका फोटोकॉपी जिसे मार्क एक्स किया गया है. इन्होंने अपने प्रति परीक्षण के पैरा 12 कौशल कुमार सिंह अंकुर कंपनी में कब से काम किया है ये मुझे मालूम नहीं है. इन्होंने अपनी प्रति परीक्षण के पैरा 2 में बताया कि कौशल कुमार सिंह अंकुर कंपनी में कब तक काम किया ये मुझे नहीं मालूम है। विपक्षी की ओर से एक साक्षी का साक्ष्य न्यायालय में प्रस्तुत किया गया है। विपक्षी साक्षी संख्या 1 अजय कुमार श्रीवास्तव, उन्होंने अपने साक्ष्य में बताया है कि मैं कौशल कुमार सिंह से कभी कोई रुपया कर्ज नहीं लिया हूँ। उन्होंने अपने बेटे से मालूम था कि अंकुर सीड्स कंपनी कार्यालय रांची में मुद्दे का काम करता था तथा इनके बेटे श्रीधर श्रीवास्तव के साथ जान पहचान था। अंकुर सीड्स कंपनी रांची में इनके नकदी उधारी लेन देन होता रहता था तथा इनका बेटा श्रीधर श्रीवास्तव ने 5 सिक्योरिटी चेक अंकुर कार्यालय में विश्वास करने हेतु दिया और इसी में से एक चेक को बेईमानी करने की नीयत से मुझे कौशल कुमार सिंह 5 लाख रुपया ठगने के लिए ब्लैकमेल कर रहा है। उनका ये भी कहना है कि कौशल कुमार सिंह का केस झूठा है। हाँ, सेम, इट्स द सेम थिंग, he reiterated the same thing. Now interesting would be,
That's it, now you come to the point.
but
We have read it full text.
yes, on full text, but then again the essential would also be deposition of complainant if it is also seen.
This is it. We have read it. We have read the deposition of complainant also.
Because whatever is written and taken, the part which has been allowed here in the judgment, well, it is not all. If because whatever questions were asked, the cross examination, what he has deposed entirely before the court, well, it's in a particular form.
We appreciate. Show me some law. Was it what was it that has not been considered?
Yes, Malas, I'm here.
You are just saying that
Plus,
preponderance of probability. This
ultimately, yes, well, ultimately, my case is that I had tried to shift the burden upon the accused.
But you have failed to shift. As
No,
per,
plus there is-
as per 2 courts.
As per 2.1, they might be also been, that is my case, is 139 and 118. It is against me.
That's
Hence,
it. That's it.
so if the deposition of complainant only leadership.
Which paragraph do you want to rely upon? कौन सा कोर्ट रिविजन में इतना सुनता है? I just want to know.
Well,
I'm hearing
I'm
you
happy.
for half an hour. You want to read the entire.
Because it is
deposition.
entire conviction, because it would be, because if it is I fail, I have this,
That's right.
so at least my one opportunity where I can
No,
place all the records.
I'm giving you sufficient opportunity. I'm absolutely vocal in disclosing what is going on in my mind. But you don't respond to any one of them. You have your own trip.
But because leadership, my,
The reply to your complaint, the legal notice, is totally contrary to your evidence.
that is coming from,
That is clinching.
that is coming from the court malice. But then again, if I take it as a prudent mind, because even as a layman, if I take it,
in whatever manner you want, but I have to think as per law.
well, if I take it even as a layman, well, what would a layman would do if he is subject to such
This
questions?
is not a proceeding where we can take a layman's view.
But the depositions have come
We have
have
seen
come
it.
from
We
the
have
mouth
seen
of
it
the.
from We have seen it. That is all.
The deposition of complainant if it is taken.
Which paragraph?
Well, there are certain paragraphs of the.
And on what point?
On contradictory point, on the point that at least because presumption favors the complainant, it is clear that I do not go into this point, but then against the liability and the deposition which the complainant had deposed before the court below, well, it is surprisingly that he doesn't give a particular detail. He just say he doesn't have the knowledge. He doesn't give the entire detail, not the entire detail. He doesn't give not even single detail about the transaction which took place between him. He doesn't remember the date, time, place of the occurrence.
It was just a loan.
He says he was just a loan.
It is not a business transaction that he will give you all the transaction details.
But then, but the check was
Just a
given.
loan.
He doesn't know when the check was given to him.
Very good.
He
Check
doesn't
has its own
discloses the
date.
time, place where the check was given to him. So this is something which would sufficient enough to create a doubt in the mind.
No, that is not sufficient enough.
If it is seen at a while, if only for a while,
Let
then
us see what is the appellate order.
appellate order starts from page 15, and the findings is recorded starts from page 17. And the findings first paragraph is allowed to be used. This is the important. Paragraph 8. The findings, the very first paragraph, this note quotes, he records as learned counsel for the appellant convict is submitted that the court below erred in law and facts both. It is contained the complainant respondent has failed to establish mode, place, date, wise amount of payment of loan to the appellant convict, but the court below did not consider. It also contained the appellant convict is extremely old man. He has never took a pipe from complaint. He was quite stranger for the complaint. He has replied to the legal notice by Exhibit 1. It is also contained that appellant convict has been treated as his son. She was trusted the complaint respondent by handing over the checks of security to be deposited in Messrs. Ankusi's Private Limited, Ranchi, from where the appellant convict and his son purchased in wholesome the agriculture items to carry on business as a Bihar seed shop situated in Latehat, but the learned lower court did not consider. Therefore, an appeal may be allowed in judgment and order of conviction sentence passed by the learned court will be set aside. So it was also contended that he failed to establish the mode, place, date, wise amount of payment of loan to the appellant convict. This was the primary submission before. Now, on the other hand, learned counsel for the complainant respondent submitted that complainant respondent has successfully proved the case beyond all reasonable doubts, and conviction and sentence imposed upon the appellant convict by the learned court below is proper and no case is made about for interference. Now, heard both the parties and perused the record. Before proceeding further, it is useful to consider the provision section 130, 139, and 118 of the NI Act. Section 130 of the NI Act requires that a check drawn by a person on account maintained by him with a banker for payment of any amount of money to another person from out of that account for the discharge in whole or in part, or any debt or any other liabilities written by the bank unpaid, either because of the amount of money standing to the credit of that account is insufficient on the check that is according to some arranged to be paid from the account by an agreement made with the bank, such person shall be deemed to have committed an offence. In order to consider an offence under provision in section 118 of NI Act, requires that the check must be presented to the bank within a period of 6 months from the date of the check, and it must be dishonored for the reason mentioned under section 138 of the NI Act, and the payee or the holder in due course of the check, as the case may be, makes a demand for payment of the said amount by giving notice in writing to the drawer of check within 30 days of receipt of the information from the bank regarding the return of the check as unpaid, and the drawer of the said check fails to make the payment of the said amount to the payee or the holder in due course of the check within 15 days from the date of receipt of the notice. It constitutes an offence punishment in section 138. This ignores and necessary to consider.
Finding
You
of
want to
the
cite any judgment apart from this? Yes, counsel. Any judgment, any more judgment you want to cite?
Unless two more.
No, I will not give you any time for that.
No, I was.
What is the judgment you want to cite?
Unless only on presumption and on this point.
Where is that judgment?
But though I have presented one judgment now, and on this same point, because I have this.
It can't be like this. You are absolutely non-serious. Why you don't bring the judgment and you say that?
No, we could do that. No, because we eventually and gradually we are being asked questions that comes from the court, and to just want to, if given a chance, if we are on some clarification, if it is needed, it will obviously come gradually. So now that this point has come to me, apart from presumption, if my lord is not satisfied the presumption part on the opportunity which was afforded.
जजमेंट पार्ट में अगर देखा जाए उसमें जो कोर्ट का जो फाइंडिंग है, जस्ट आई एम रीडिंग नोट से, यहाँ न्यायालय का मानना है कि मुदालय का बेटा श्रीधर श्रीवास्तव ने मुदई कौशल कुमार से 5 अंकुर सीड्स कंपनी में जमा करने के लिए दिया था। यहाँ मुदा पेज नंबर 12 है, 12 पैरा 8 सेकंड पैराग्राफ पढ़ा दीजिए। यहाँ न्यायालय का मानना है कि मुदालय के बेटा श्रीधर श्रीवास्तव ने मुदई कौशल किशोर को 5 अंकुर सीड्स कंपनी में जमा करने के लिए दिया था। यहाँ मुदालय का अपना बेटा श्रीधर श्रीवास्तव का साक्ष्य प्रस्तुत करना था, जिसे मुदालय ने प्रस्तुत नहीं किया। अंकुर सीड्स कार्यालय में 5 चेक यदि दिया था तो विवादित चेक के अलावा और कौन कौन सा चेक था उसका भी वर्णन मुदालय द्वारा नहीं किया गया है। न्यायालय में मुदालय द्वारा प्रदर्श बी जो प्रस्तुत किया गया है, इस प्रदर्शकारी का हस्ताक्षर व मुहर नहीं है। इसके अलावा इस पत्र में बहुत जगह कटिंग है। कटिंग के स्थान पर किसी भी पदाधिकारी का हस्ताक्षर नहीं है। इस प्रकार यह पत्र विश्वसनीय नहीं है। मुदालय की ओर से निम्नलिखित रूलिंग दाखिल किया गया। पैरा 9 देख लिया जाए। उपरोक्त गवाह एवं दस्तावेजों साक्ष्यों को देखने के पश्चात दोनों पक्षों के विद्वान अधिवक्ता को सुनने के पश्चात न्यायालय यह पाता है कि चेक पर हस्ताक्षर अभियुक्त अजय कुमार श्रीवास्तव ने ही किया है, जिसका कहीं से वे इनकार नहीं करते हैं। और उसी की तरह चेक बैंक में दिया गया तो बैंक द्वारा उक्त चेक को खाते में अपर्याप्त राशि होने का प्रमाण पत्र देकर वापस कर दिया गया, जो प्रदर्श 3 के रूप में अंकित किया गया। इस तरह वकालत नोटिस को प्रदर्श 5 अंकित किया गया है एवं रजिस्ट्री स्लिप को प्रदर्श 4 अंकित किया गया है। इन सभी दस्तावेजों को देखने से स्पष्ट होता है कि अभियुक्त अजय कुमार श्रीवास्तव के खाते में अपर्याप्त राशि रहते हुए परिवादी कौशल कुमार को 5 लाख रुपया का चेक दिए हैं। अभियुक्त अपने पक्ष को साबित करने में असफल रहा है, जिससे यह बात सिद्ध होता है कि उक्त चेक उन्हीं के द्वारा हस्ताक्षर कर दिया गया है। अतः परिवादी अपने द्वारा लाए गए दस्तावेजी साक्ष्यों एवं गवाहों के बयान से अपने केस को अभियुक्त अजय कुमार श्रीवास्तव के विरुद्ध धारा 138 एनआई एक्ट के तहत युक्त रूप में हर संदेह से परे सिद्ध कर पाने में समर्थ रहा है। अतः अभियुक्त अजय कुमार श्रीवास्तव को 138 एनआई एक्ट के तहत दोषी पाते हुए न्यायिक अभिरक्षा के लिए लिया जाता है।
As the court time is over, court post this case for qualification of
Item 4, pass over case.
Sir, your matter is here.
Yes.
This revision is not maintainable.
Yes, of course, on the basis of the judgment of the Supreme Court in Stephen's case,
Yes.
it is the appeal should be filed. Because what the 397 and 401 CRPC also will say that the revision has already filed, the second revision will not lie. But here, against the order of acquittal, the appeal will lie if not the complainant, the victim has got any grievance against the order of acquittal, then he has to file appeal under section 372 CRPC. And this has been answered by the Supreme Court in case of Joseph Stephen at paragraph 10 also. Rather not 10.2, I am reading the relevant line. The right provided to the victim to prefer an appeal against the order of acquittal is an absolute right. And 372 CRPC says like this. Because there was no provision of appeal earlier, so far victim is concerned.
As observed by this court in Mallikarjun.
Yes, but I am reading it. As observed by this court in the case of Mallikarjun Kodagali, Supra, so far as the victim is concerned, the victim has not to pray for grant of a special leave to appeal, as the victim has a statutory right of appeal under section 372 proviso. Because earlier there was no proviso, to section 372. So now the proviso has been considered, and the proviso to section 372 does not stipulate any condition of obtaining a special leave to appeal like subsection 4 of
What do you
378.
want in your case?
Pardon?
What do you want in your case?
My lord, I want to convert this
Convert it.
in the appeal because there will be much more scope
Certainly.
in appeal than the revision. So in view of the judgment of the Supreme Court in Stephen's
Where
case,
is the respondent? Nobody is there. Notice has not been issued. it
In
seems.
the list, name of the opposite party number 2 is there. In the list. But
notice has been issued.
appears are there.
The notice has been issued, notice of validity served to the party, and one of the learned counsel is appearing also, his name appears in the cause list.
In the first, when it was called out, the council was there. We post it tomorrow, okay? You come tomorrow.
So this
In the
is
morning
very,
only this case will be taken
yes,
up, but
madam,
I don't want to pass an order in his absence.
yes, madam,
Because
this
he
is the
should also
formal,
be put to notice.
formal order of your there.
I know you are junior Murthy there, that
Yes,
should be
madam.
sufficient.
Madam, yes, it may be
But
kept
in
on.
his absence, it is already 4:30, so I don't want any adverse order after 4:30.
Any, it may be kept to what?
Yes, serial number, concern?
39.
The learned senior counsel for the petitioner has fairly referred to the judgment passed by the Honorable Supreme Court in the case of Joseph, Stephen and others versus Santhan, Sami and others, reported in 2022 Law within bracket S3 and has referred to paragraph 10.2 of the judgment to submit that the petitioner, being the victim, has filed the present case against a judgment of acquittal passed by the appellate court. And therefore, the petitioner has an independent right of appeal before this court, and therefore the present revision application is not made. Since the opposite party is not present,
Even
number
not
2
the-
is not present,
in view of
and the
not this
counsel
section.
for the state is present.
And my lord may indicate not, in view of section 401 CRPC, my lord, if not under the erroneous belief, if the revision is filed and appeal is maintainable, it can be converted.
Yes. The learned counsel has further submitted that under section 401 the CRPC, if the revision has been erroneously filed, the court has a discretion to permit the petitioner to convert it into appeal. The learned counsel submits that appropriate order be passed so that the present petition is converted into appeal. Counsel for the state is present. You have any objection to this? कल आप सुबह 10:30 बजे नहीं आएंगे तो अभी से record करें.
None.
The learned counsel appearing on behalf of the opposite party state has no objection to the prayer. Since nobody is appearing for OP number 2, post this case tomorrow for application.
And why not this appeal is maintainable? Because not under section 401 CRPC, subsection 4 says, my lord, that in revision jurisdiction the court cannot convert into lord the acquittal into conviction. Yes.
Today, once counsel was arguing that okay, you cannot convert it, but you can set aside the order of appeal and remand it back. I am not very inclined after I've read this judgment.
Right.
So I think that would also be an incorrect proposition.
Lord, the earlier lord used to file lord the criminal revision in a police case, my lord, because the victim has got no right. The estate may not take, and the estate has got right to file lord the appeal against acquittal.
That's right.
So, my lord, there was no lord provision in CRPC. Then, lord, as per section 372 CRPC, the only revision. Yes. Now, lord, the 372 is there, the provision is there, therefore.
ये सारी judgments जो हैं, इसको कल के लिए कर लीजिए 700 of 2022, ठीक है?
Let's say serial number 28 that is also against the conviction acquittal under 138 Act.
Yes, you were there. Same order will be passed.
Yes,
If you
for
want
that I have moved the
There is one difference in
Joseph
that case.
Stevens.
No, your
No,
lordship,
there is one difference in that case. He has not moved the sessions court. He has directly come after the trial order, challenging the order by the trial court.
Appellate court has acquitted the conviction.
No, Your Lord. In his case, a learned trial court has acquitted.
You are talking about other case?
Yes.
Okay, in that case, what has happened?
I have been the petitioner has been against acquittal. The revision has been filed, your lordship.
Against acquittal passed by which court?
By the first court.
Learned
that is-
Division court or appellate court?
Trial
No,
court.
trial court, your lordship.
So
That is
straight
not-
away, yes.
Straight
come.
away.
That is not
Straight
maintainable.
away.
Yes, sir.
That is not maintainable. Otherwise, also we have kept it tomorrow, no?
Yes,
We have kept it tomorrow.
Yes, Your Lord.
Yes, your lordship.
We'll pass appellate order.
Much of that.
Madam, you be there. Don't be absent.
No, Your Lordship, actually बहुत सारे cases लगे रहते हैं.
It's good.
अच्छा है ना?
You should have more and more juniors and give the fight to them.
अच्छा है, पूरा केस समाज में ये
ज़्यादा लोगों को डेवलप करिए.
हम लोग को कोई उपाय नहीं है
बहुत
जूनियर
मुश्किल होती है leadership.
जूनियर को रखने का क्या? खुद से रखना है.
खुद से.
But they can't appear here.
They can appear because if I pass any order in your favor, I will not call upon you. But if I have to pass any order which is against your client, then I will certainly call upon you. They can give them some opportunity to argue. Pass over अगर मांगेंगे तो हम उनको सुन के हो सकता है आपके फेवर में.
हम लोग भी TPs and the special TP, they are getting probably much more. I think not the adequate fee.
You cannot decide what is an adequate fee for the council.
No, Lord, if I compare if I
You
compare,
just can't.
if I compare Lord the earlier
You
fee,
can't.
which was being paid to the special PP, then what I am saying,
They
comparing
deserve
that,
They deserve more.
आप नहीं बोल सकते
नहीं, हम अपना compare कर रहे हैं.